I think it's a great question to open up the issue of the differences between family and criminal law, and why something that could work in family law might just not be possible to work effectively in criminal law. So what do I mean by that? And I do want to say right at the outset that without proper judicial education, and Agnes, I'm not quite as optimistic about Ontario judges as you are, and education for lawyers, it doesn't matter how great the law is, because the people who are applying it, the people who are interpreting it, have to understand what it is they're interpreting and what the ultimate goal of the law is. But if we can just set that aside for a minute and think about the law as it's written, I think there's a really big place for coercive control in family law, because family law is not about determining whether somebody's guilty of something. It's about what are the best arrangements for the children. And as all of us know, and a number of you have already said, coercive control is a sort of all-encompassing reality for the victim, the primary victim, but also for any children who are in the household while that kind of behavior is going on. It absolutely, in my opinion, has to be part of a definition of family violence. And as the Divorce Act in BC and Ontario and some other provinces, provincial legislation says, you got to consider family violence when you're making any decision related to the children. Family law can, in fact, and must and does look not at single incidents, but at the whole story. What went on over the 10 years of this relationship, or the 5 years of it, whatever it was. This is where we get into trouble, where we just try to sort of move a concept from family court into criminal law, because as you said, Angela, criminal law is single incident focused. Did this individual person on this specific date do this particular thing? And that's not what family violence, intimate partner violence is, especially not coercive control, because it's happening every day in one way or another. So you can find evidence to meet the family law standard of proof on a balance of probabilities if you've got the right players, if you've got the right judge, if you've got the right lawyers. It's not impossible to tell a story about coercive control that will lead to a safe outcome for the family. In criminal court, how do we even start? Police officers, with all due respect, are not even that good at laying charges appropriately when there's been an incident of physical assault. And we see how abusers manipulate that moment where the police become involved. We see where all of the intersectionalities that Deepa was talking about a few minutes ago come into play on behalf of both the primary victim and the person who's causing the harm. If they can't get it right to figure out that he punched her in the face, how is a woman going to explain, well, over the last 10 years, he's made me feel like a worthless piece of shit because he's taken over all the decision making. He doesn't let me see my family, and so on. Plus, the standard of proof in criminal court is different. It's beyond a reasonable doubt, as it should be. We don't want people going to jail because somebody thinks maybe they did it. But the whole concept of coercive control, you can't just transplant it from a family court system that's not about guilt, but about finding a way to move forward and that looks at the whole history of the family, into the criminal court where we're looking at what happened on this day and is this person guilty of having committed a crime.